Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name's Mark Solomon, a defense attorney in Denver, Colorado, and today's question, how are juvenile cases different? But before we get to that, don't forget to click like and subscribe with a little bell next to it to be notified of future videos. Let's get to the question. How are juvenile cases different? We got a question from a subscriber in the UK who was asking about how juvenile cases are different. Is the law different? Are they treated differently? Very good question. The answer number one is all the criminal laws themselves are the same, although the offenses have to be proven in the exact same way with the exact same elements, except for things like minor in possession, where obviously one of the elements of the crime is somebody has to be underage. Past that, if the person is charged as a juvenile meaning under age 18, they can only be held in Department of Youth Services until they're 21, and they are generally handled easier. In other words, depending on the severity of the charge, the prosecution works along with the court. Often guardian ad litems are appointed, and the standard is the best interests of the child. They're not called the defendant, they're called the juvenile. If they want the case to be proven beyond a reasonable doubt, it's not called a trial, and they don't get a jury. It's called an adjudication, and it's to a judge, or some cases a magistrate. So let's look at some of those statutes. So first off, to be a juvenile accused of an offense can't happen if you're under 10, but juveniles can be aged 10 through just under 18. Once you hit 18, then you can be charged with an offense. There are other laws that apply, such as the jurisdiction of the court, which again talk about different ways you can be prosecuted. Also, the informal adjustment up from when you're charged and sentenced. And again, here's the law on the commitment to youth services. Now, very important, there's some other laws that I didn't put on here. And what they mainly talk about are the differences if somebody is not going to be charged as a juvenile. Okay, so in other words, somebody commits a murder, or a robbery, a sexual assault. It is very highly likely, especially if they're aged 15, 16, or 17, to be charged as an adult. And there's two ways this can happen. Number one, they can be charged as a juvenile, and then the case can be transferred up to district court to be charged as an adult. Obviously, you can fight this at different levels of the proceeding. Sometimes the state can ask for it to be transferred up to district court, and then you can fight to get it removed back to juvenile court. The other way, the prosecution in a very heinous case could actually direct file, meaning that they just indict the juvenile as an adult, and then they're fighting an adult case from the beginning. So very good question. There are a lot of things that I left out here, but if anybody has any follow-up questions, please ask me in the comments below. So that was the question and answer for today. If you want to submit your own questions, put it in the comments below. Tag me on Twitter or email me. Obviously, you still have a right to remain silent. If the police ask you the who, what, where, when, or anything, you have a right to remain silent and say, I don't want to talk to you, or I want a lawyer. Thanks for watching.